Hello everyone and welcome to today's webinar hosted by Peter Ong Law Corporation and Economy Holdings Private Limited. My name is Shamila Nair. I am a registered foreign lawyer for Peter Ong Law Corporation and I will be your moderator for this session. Today, our speakers, Mr. Peter Ong and Mr. Bu Kok Chuan, will address the question of what to do if you cannot continue with your contractual obligation due to COVID-19. Briefly, our speakers will discuss issues of force majeure, the doctrine of frustrations, and the recently enacted COVID-19 Temporary Measures Act. I would like to introduce today's speakers, beginning with Mr. Peter Ong, who is the Managing Director of Peter Ong Law Corporation. Not only is he qualified as an advocate and solicitor in Singapore, he is also called to the Malaysian bar. Mr. Peter Ong handles cases in the areas of civil litigation, arbitration, and criminal defense. To date, he has successfully secured over 70 acquittals for his clients. Maybe one day we'll be fortunate to have him share some insights in the area of criminal defense. Founder and Managing Director of Economy Holdings Private Limited. This company has its presence in Singapore, Malaysia, and Hong Kong. He provides corporate, development, and investment management consultancy to businesses within the region. Just a little housekeeping before we get started. If you have any questions during the presentation, please type them into the chat box in your control panel. If you would like to specifically address your questions to either Mr. Peter Ong or Mr. Bu, please also state so. We will address your questions at the end of our speaker's presentation. Without keeping you waiting any longer, we will turn the time over to Mr. Peter Ong.
Good afternoon, everyone. Welcome to our webinar. The COVID-19 pandemic has caused unprecedented disruptions to most, if not all, businesses around the world, including Singapore. Unsurprisingly, people are worried about the consequences of being unable to carry out their obligations under their contracts and how the COVID-19 pandemic would affect their obligations under such contracts. In determining how one's obligations will be affected and what consequences may follow, much will depend on the terms of the contract, whether there is any force majeure clauses involving any epidemic occurrences, the extent to which a party's ability to perform his obligations under the contract due to the COVID-19 pandemics, and the type of contract in question. In this webinar, we will briefly discuss force majeure clauses, the common law, doctrine of frustration, and recently enacted COVID-19 Temporary Measures Act is in effect. We also further emphasize that the effect on a party's contractual obligations and its consequences will differ depending on which avenue is invoked. For the benefit of some of you who may not be familiar with how contracts are formed, there are 4 elements of a valid contract. Mainly, they are offer, acceptance, considerations, and intention to create legal relations. Let's start with offer. Contracts are always start with an offer. An offer is an expression of a willingness to enter into a contract on certain terms. It is important to establish what is and is not an offer. Offer must be firm, not ambiguous or vague. A person who is making the offer is called the offeror. Offers are different than an invitation to trade. An invitation to trade is not an offer. When you list your home for sale, you are not making an offer. You are making an invitation to trade. You are inviting potential buyers to make an offer to you to buy your home. The same is true with most advertising. The stores are making an offer to trade. They are expressing their willingness to sell you something if you offer them their asking price. However, they are not bound to accept your offer. For example, you place an ad online to sell your car for a certain price. Someone makes an offer to buy the car from you at full price. Do you have to accept the offer? No. You are making an offer to trade, and you are not bound to accept their actual offer to buy your car. Now let's talk about acceptance. Acceptance by the offeree, that is the person who are accepting your offer, is the unconditional agreement to all the terms of the offer. There must be what is called a meeting of the minds between the parties of the contract. This means both parties to the contract understand what offer is being accepted. The acceptance must be absolute without any deviation. In other words, an acceptance in the mirror image of the offer. The acceptance must be communicated to the person making the offer. Silence does not equal acceptance. When we talk about acceptance, we also talk about one rule, what we call the poster rule. This rule was established by a series of 19th century cases. The poster rule applies only to acceptance. Other contractual letters, such as one revoking the offer, do not take effect until the letter is delivered. The implication of this is that it is possible for a letter of acceptance to be posted after a letter of revocation of the offer has been posted. But before it is delivered, an acceptance will be complete at the time that the letter of acceptance was posted. The offeror's revocation would be inoperative. Now we talk about consideration. Consideration is the act of each party exchanging something of value to their detriment. For example, A sells A's car to B. A is exchanging and giving up A's car while B is exchanging and giving up B's cash. Both parties must provide consideration. In relation to consideration, there is also one thing what we call past consideration. Voluntarily, doing something for someone is not consideration. A sees B's lawn needs to be cut, so A voluntarily does so. B comes home from work and is so pleased that B gives A $30 for cutting the lawn. The following week, A cuts B's lawn again without B asking A to do so. A now asks B for $30 for cutting the lawn, and B refuses to do so. A claims that they have a contract since A has provided consideration by moving B's lawn, even though it was voluntary. B is incorrect. B is not obligated to provide consideration to A. There is no contract. However, if B had asked A to mow the lawn, but did not set the price, A would probably be able to enforce the contract after mowing the lawn because B requested to do so. The fourth element that is intention to create legal relations. The fourth required element of a valid contract is legality. The basic rule that is that courts will not enforce an illegal bargain. Contracts are only enforceable when they are made with the intention that they are legal, and that the parties intend to legally bind themselves to their agreement. An agreement between family members to go out to dinner with one member covering the bill is legal, but it's not likely made with the intent to be a legally binding contract. Just as a contract to buy illegal drugs from a drug dealer is made with all the parties knowing that what they are doing is against the law, and therefore not a contract that is enforceable in court. Privity of contract. A common law doctrine which prevents a person who is not a party to a contract from enforcing a term of the contract, even when the contract was made for the purpose of conferring a benefit on the third party. In Singapore, the Contract Rights of Third Party Act reformed the privity of contract rule and gives a person who is not a party to a contract a right to enforce a term of that contract is specific in specific circumstances. Terms of contract. A term may be incorporated into a contract either expressly or impliedly. Express terms are those which have been explicitly communicated between the parties orally or in writing. The intention of the parties is clear, and there is little discussion to be had of this. Implied terms are those terms which fill the gaps in the contract. Terms can be implied in the following ways: trade usage, nature of relationship, unexpressed intention of parties, operation of statute. Terms implied by trade usage. There are three main requirements are: the term is clearly established and notorious in that trade context. The term is not inconsistent with any of the expressed terms. Both parties must be involved in the trade context in such a way that they would be expected to be aware of the term being custom in that context. Term implied by law. Terms in law can be implied irrespective of the intentions of the parties. They relate to legal obligations imposed either by the court or by statute. Terms implied by the court. The basic requirements for a term to be implied by courts are: the term is implied in all contracts of that type as a policy matter. The term must be necessary. The term must be reasonable to imply. Terms implied by statute. Where it has been deemed necessary by the legislature, certain terms have been implied in contracts by statute. The most obvious example of this relates to the sale and supply of goods. In Singapore, we have the Sale of Goods Act. Now let's turn to the main topic of the day: frustration of contract. You can see a QR code at the right side of your screen for you to download the handout of this topic. Force majeure clauses. On the assumption that a contract had been validly performed, the next consideration would be to turn the terms of the contract in question, and in particular, the existence of any force majeure clauses. Generally speaking, force majeure clauses are clauses which represents a bargain allocation of risks, which may, for instance, excuse the non-performance of a contract or allow the party to delay the performance of his obligations in defined situations. As a force majeure clause is an agreement as to how outstanding obligations should be resolved upon the onset of a foreseeable event, much will depend on the contractual interpretation of the force majeure clause, which the party seeks to invoke. Accordingly, the issue of whether the COVID-19 pandemic is a force majeure event and its potential relief that the party is entitled to would depend entirely on the wording and interpretation of the force majeure clause in question. Therefore, where the force majeure clause in question requires that the force majeure event, say for instance any epidemic, to hinder and or prevent the performance of the contract, the affected party intend to reply on the force majeure clause would need to first show that the COVID-19 pandemic constitute a force majeure event within the meaning of that clause, and that the occurrence of the COVID-19 pandemic in fact caused hindrance or prevention. One would then ask, what would happen if I successfully invoke a force majeure clause in the contract? Again, as discussed above, and unlike the common law doctrine of frustration, the recourse would entirely depend on the force majeure clause invoked. For instance, it may excuse the non-performance of a contract or postpone the obligations of the party to later stipulate to a stipulated date. Now let's just talk about the frustration. Common law doctrine of frustration. In the absence of any force majeure clauses in the contract in question, one should consider whether the common law doctrine of frustration applies. There are numerous ways as to how contracts may be discharged, but for the purposes of our discussion, we will only focus on the discharge by frustrations. Typically, contracts may be discharged when is discharged by performance. Parties to the contracts have completely performed all of their rights and obligations under that contract. Discharged by breach, where one party to the contract has breached a term of that contract, where the term breach is one which allows the innocent party to bring the contract to an end. Discharged by mutual agreement, where parties to the contract mutually agrees for the contract to come to an end. And discharged by frustration, where an event beyond the control of the parties and beyond their reasonable foresight occurs in the circumstances for which neither party is at fault, which renders impossible further performance of the contract. A contract may be said to be frustrated when someone renders it physically or commercially impossible to be fulfilled, or transforms the obligation to perform into a radically different obligation. Depending on how the COVID-19 pandemic has affected a party, he may wish to rely on the doctrine of frustration. If the COVID-19 pandemic had rendered it impossible for the contract to be fulfilled, or that there is a radical change of its obligations. To be precise, what is frustrated is not the contract itself, but the contractually stipulated performance expected of the contracting party. It should be noted that the doctrine of frustration is not easily invoked and remain confined to exceptional circumstances. Based on our research, there has also been any Singapore cases deciding on the issue of frustration caused by pandemics similar to COVID-19. Having said so, it is still possible to analyze the COVID-19 pandemic in light of three broad categories, which will be discussed in term below. Physically impossible, legally impossible, and futile. Because it is now impossible to achieve the underlying common purpose of the parties in entering into the contract. Physical impossibility. Essentially, physical impossibility refers to cases where performance has become impossible. The impossibility may be divided into four subcategories. Cases where the subject matter of the contract has been destroyed. Cases where the contractual promisor has died or become physically incapacitated. Cases where the subject matter of the contract has become unavailable. And fourth, cases where the source of supply of the subject matter of the contract has failed. Let's touch on the subject matter of the contract has been destroyed. This category is a straightforward one. Suppose you enter into a contract to hire from the other party a musical hall, which was to be used for grand concerts and fetes. However, before the performance that the musical hall was to be used for, there was a fire and the hall was destroyed. Neither party was at fault for the destruction. In such scenario, it may be said that the subject matter of the contract has been destroyed and the destruction of the subject matter has rendered the performance of the contract impossible. Contractual promisor has died or become physically incapacitated. Suppose that the contract in question is to be performed by a particular promisor personally, in the sense of its performance is not to be delegated to any other entity. Should the promisor be incapacitated in such a way as to render the impossible for the contractual performance to be carried out personally by the promisor, the contract may also be found to have been discharged by frustration. Another example, this would be where the contract of employment was frustrated by the death of the employee, and where the employer is a natural person, the contract may also be frustrated should the employer die. Unavailability of subject matter. Suppose there is a contract for the sale of landed property. Prior to the completion of the contract, the Singapore government compulsorily acquired the property in question pursuant to Section 5 of the Land Acquisition Act. This may be an example where the subject matter is in question becomes unavailable. Failure of source of supply. In most instances, contracts for the sale of or supply of goods or services do not specify precisely from where or by whom they are to be supplied. For instance, most purchasers who purchases goods like apples and rice are not particularly concerned as to their source so long as the peppers or rice fit in the contract description. In some cases, however, the source of the supply may be a critical part of the contract. For instance, in the case of Howell against Copeland, Copeland had agreed to sell Howell 200 tons of region potatoes grown on land belonging to Copeland. In an ordinary growing season, there would have been an ample crop to satisfy the contract. However, a disease attacked the crop and caused it to fail, and resulted in Copeland being able to only deliver 80 tons. The English Court of Appeal agreed to treat the contract as having been discharged by frustration. Legal impossibility. This occurs when circumstances have arisen so as to render the performance of the contract illegal. For example, a possible case involving legal impossibility could be that the performance of an obligation, for instance, holding of concerts. This has been prohibited by law, the introduction of COVID-19 Act, to give legal force to ensure that everyone stays at home and to ensure safe distancing. Impossible to achieve the underlying common purpose of the parties. There are instances where the supervening event does not have a dramatic effect. Sometimes the occurrence of a supervening event may not render contractual performance to be strictly impossible, but nonetheless would be regarded by both contractual promissor and promise to be futile in light of the supervening event. The question is, what happens when contract is frustrated? At common law, once the court concludes that the supervening event, for example, COVID-19 pandemic, is indeed a frustrating one, the contract is said to automatically come to an end, and the parties are discharged from their obligations under the contract. However, in some cases, the frustration of the contract may lead to an unfair outcome. For instance, where one party has incurred costs in his attempt to perform his obligations under the contract. One might therefore ask, what happens in such a scenario? The Frustrated Contracts Act comes to help. It was enacted to resolve any unfairness that may arise from the frustration of the contract. While it is within the scope of this webinar to discuss the FCA in full, we will want to highlight Section 2 of the Frustrated Contracts Act. Briefly, the FCA permits the recovery of all sums paid prior to the frustration of the contract. The court to allow the payee to either retain or recover money for expenses incurred before the frustrating event, if the court considers it is just to do so. And party who has conferred a valuable non-monetary benefit on the other contracting parties by virtue of its partial performance of the contract to be awarded compensation. It should be further noted that the FCA only applies if the contract is not excluded under Section 3(5) of the FCA. The Act shall not apply in a charter party, except a time charter party or charter party by way of demise, to any contract of insurance, except as provided by Section 2(6) of the Act, to any contract which Section 7 of the Sale of Goods Act, which avoids contracts of sale of specific goods which perish before the risk has passed to the buyer applies, or to any other contract for the sale or for the sale of and delivery of specific goods where the contract is frustrated by reason of the fact that the goods have perished. In conclusion, based on our discussion above, The effect on one's contractual obligation and its potential consequences would differ from contract to contract. It is therefore important to analyze the contract in question and the relevant legal avenues that might apply. As discussed earlier, the terms of the contract, the type of contract in question, and the extent to which a party's ability to perform his obligations arising from the contract is impacted by the COVID-19 pandemic will also have a bearing on legal analysis. I will now invite Mr. Bu to share on the applicability of the COVID-19 Temporary Measures Act.
Thank you. Thank you, Mr. Peter, for the very comprehensive introduction to contract as well as the various discharge avenue where a contract could come to an end. And thanks to Shamila for the introduction earlier on. Now I'm going to touch on a recently enacted law called the COVID-19 Temporary Measures Act, which was introduced in Parliament in February this year. The purpose of this law was actually to resolve some of the problems and predicaments that small and medium enterprises could face in light of the COVID-19 crisis that we are facing right now. As discussed in the earlier context by Mr. Peter Ong on frustration, on how certain contract can be discharged through means of frustration, there remains a certain barrier to prove that a contract is being frustrated, especially in the context of common law. And not only that, it's also, based on what has been researched by our firm, there isn't any local case law that can support such a frustration due to public health issues like that of a pandemic. So instead of passively relying on the common law to balance out, to justify the situation, our government has also introduced this new law, which is seeking to resolve some of the problems that has brought towards the business community in Singapore, given that this pandemic is very widespread and has affected the whole economy and the whole market on a very wide scale. So what is the problem that this COVID-19 Temporary Measures Act, or in short we call it the COVID-19 Act, something to resolve? Essentially, there are a few parts to this new law, and today we shall just focus on the part that relates to our contact of this contract. So as far as our topic is concerned, this new law actually deals with contracts that are related to three broad categories. First of all will be the commercial undertakings that the firm has actually undertook. Secondly will be the commercial and industrial tenancies. And thirdly, the individual consumer transactions. This act actually provides very specific particulars on what exactly are the contracts being covered, which I will be coming to that shortly. And the objective of this new law is actually to help defaulting parties to overcome this situation that has been impacted by the COVID-19 outbreak. Because this pandemic has been so widespread, and we are trying to prevent a situation where overnight many companies would have to face legal consequences, and also, due to their inability to continue with the obligations set out in the contract that they have previously entered into, as a result, have to face lengthy litigation or even consequences of insolvency. Okay, so this is the spirit of this whole new law that has been introduced in Parliament in March this year. So, like I said, this new law has been in place and it has been passed by the Parliament, and it allows contracting parties who are facing problem in continuing with the obligations and avenue to seek temporary relief. It is not a permanent thing. In fact, there's a certain timeline to it. And by this new rule actually doesn't comes into effect automatically. In fact, if let's say you are the party who needs to seek relief from this regulation, you have to actually serve a certain notice, which I'll come to that later. Okay, so this are the coverage that has been set out in this new law. Essentially, initially when this bill was introduced in Parliament, there were only 3 categories of contracts that were covered. Namely, first of all, would be the loans by banks and financial institutions. Specifically, they referred to loan facilities that has been extended to the SMEs of Singapore, which accounted for about 99% of all the enterprises. What sort of loans? There are certain scope to it. First of all, would be secured commercial or industrial immovable property loans. Essentially, this refers to your mortgages. Secondly, would be equipment loans, loans that are secured against plant, machinery, or other fixed assets in Singapore. And third of all would be the more generic category, which is loans that are used for manufacturing, production, or other business purposes. Things like your term loans, your working capital facilities, and all that. So besides the loans contract with the banks and financial institutions, this new law also covers construction contracts. Construction contracts that relates to supply contracts or any performance bond related contracts. The rationale behind this construction contract is they basically cover all the areas and all the levels from the developers all the way to the banks and financial institutions that supply this performance bond that is related to this construction contract. And it not just only applies to the main contractors, but subcontractors who supply or being subcontracted by the main contractor can also rely on the various relief measures that is provided by this act to ease up some of their problems that they may be facing. The third category were contracts that were related to events or tourism dealings. Why this category is because, this pandemic, this is the first group of people that has been hit hard by the outbreak. So obviously when the government introduced this new law, these are the first group of people that they were thinking of helping to ease up some of the commitments. Okay, so events, tourism, related contracts range from your hotel bookings, your cruise bookings, your flight bookings, and all that. And not only that, but even B2C contracts such as wedding bookings. The party that is being frustrated from performing whatever duties can also rely on the provisions in this new law for the relief. Obviously, when this new bill was introduced in Parliament, the government actually received some feedbacks from the grounds, and in mid of April, they actually amended this law and included 2 other form of contracts under this coverage, namely the OTP, or option to purchase agreement, okay, which is essentially a reservation agreement for reserving a property. Apart from that, sales and purchase agreement, S&P agreement, as well as agreement for lease for the case of a leasehold property, is also captured under the coverage of this new law. There are certain conditions that parties need to fulfill before they can rely on this new law for the relief. And the very first condition that must be fulfilled is the timeline. It is stated in this COVID-19 Act that in order to qualify to seek relief under this new provision, the contractual obligations must be performed on or after 1st of February 2020. Obviously, this is a date that the parliament or the government actually opined that is the beginning of the impact of the COVID-19. And the second date requirement will be the contracts must be entered into before the 25th of March 2020. This is to prevent people from exploiting or abusing this law. So that's why they have this date, which obviously is the date where this bill was announced initially. This new law will be in place for 6 months. It's, like I say, it's a temporary measure. And after 6 months, depending on the situation and the development of the pandemic, it may be extended for another year. Okay, so how do we actually make use of this new law to seek relief? Well, essentially, if parties are unable to, deliver certain obligations under the existing contractual requirements that they have actually entered into, this law in theory actually provides an avenue for the defaulting party to seek relief by serving what they call a notification for relief to the counterparty. And by serving this notification for relief would in a way mitigate the possibility where the other party would potentially take out a lawsuit against him. Okay, however, there are certain recommendations that the Ministry of Law actually put up, in light of this new regulation. And these recommendations are there because, obviously, first of all, this COVID-19 crisis that we are facing now is a very widespread phenomena that essentially affects all the levels in the whole economy, as in all the levels of in the supply chain of the whole economy. And although the defaulting parties may feel that they have this predicament in cash flows or in the financials that deter them from continuing with their contractual obligations. But on the other hand, the non-defaulting party who chose to simply keep quiet doesn't mean that they are not facing any cash flow problems. So the very first recommendation that the Ministry of Law had was parties should at least attempt to negotiate and communicate with each other and see whether there's any way that a compromise or win-win situation could be reached, rather than go straight and tapping on whatever rights that is provided by this act. Okay, so that is the very first step that the ministry actually recommended. And if in the event that a compromise couldn't be reached, it could possibly be, the differences could be too wide, then the party that would be defaulting on this contractual obligations would be able to tap on this new law to seek relief by serving a notification for relief. It is noteworthy that for this notification of relief, it is essentially a legal document that needs to be served upon the non-defaulting party. And if the contract involves certain guarantor, the guarantor needs to receive it as well. In the case of, let's say, a construction contract, if the project involves the usage of certain performance bond, the issuer of the performance bond would need to receive this notification as well. There are certain specifications of this notification for relief and would differ from contract to contract. So if you need any advice in terms of drafting this notification for relief and the service of which, it is advisable that you seek professional legal advice. And I think Mr. Peter Ong would definitely be very happy to assist you with the drafting of this NFR if you need to. Okay. So what if you are on the other side of the picture? What if you are the non-defaulting party and you have been served with this NFR. Okay, but at the same time, you probably will be facing your own problem, and you probably would want to disagree. Anyway, this is a situation whereby the other party tried to challenge on whatever has been agreed previously. So now, because of this pandemic, you have been served with this NFR, and you too face your own problem with accepting it. So what are the avenues or choices that you can undertake? Well, the very first step that is recommended by the ministry again is communication. Okay, I think you should always try to communicate the situation with the defaulting party and try to find out what is the real problem, the real issue that they are facing. Right? And possibly you can try to sort out other form of arrangements, such as perhaps an installment plans or other creative form of payment arrangements, which would provide relief for the defaulting party without having to rely strictly on this NFR. Okay, but of course, if let's say the communication actually fails and eventually you guys really cannot sort out the differences, there is an avenue which you can, seek to provide a defense, that is through submitting an application to the panel of assessors for COVID-19 temporary relief fund. They call it the PACT, this organization. And in fact, I think one of the lawyers in Peter Ong Law Corporation is being named as assessors under this panel. And essentially what happens is when you make this application to the panel for an assessment, this panel will provide what they call an assessor's determination. And they will weigh the merits between the parties, and then they will provide what they call a recommendation in the form of an assessor's determination. And with this determination by the assessor, then the parties may rely on this for subsequent proceedings, such as adjudication, arbitration, or litigation later on. Okay. On the other hand, if you happen to receive this NFR, you may ask, can I just ignore it and pretend that I didn't see this NFR and continue to assume that the other party will have to continue with the contractual obligations, or even pretend that I didn't see it and get my lawyer to issue a letter of demand, or even take out a lawsuit against them? Well, actually you can't, because by virtue of the fact that this new COVID-19 Act, it actually provides that if you were to willfully challenge this NFR, you could be liable to a fine of $1,000 or less. Okay, so in conclusion, obviously the government has foreseen that there is this possible problem with the business community when it's come to serving its obligations in the existing contracts. That's why this COVID-19 law was introduced to attempt to mitigate these issues. But this COVID-19 Act, without doubt, okay, it has its limitation, because like I just covered, there are certain coverage that is being put in place, which sort of limits the kind of contract that is being covered by this new law. So nonetheless, if those contracts are not being covered and you've actually face certain problems servicing those contracts, you can still rely on other principles, such as the doctrine of frustration, or if let's say there's a force majeure clause in your contract, you could also rely on that. Right? So essentially, that is what I have for you today. And we've come to the end of this presentation. We thank you for your attendance, And if you need any legal advice, you can look for Peter Ong Law Corporation. This is the QR code that will lead you to the contact card where you can save it. And besides, I have just launched a book, Corporate Direction, which is an ebook for directors of small and medium enterprises. In this book, you will find all the necessary compliance requirements for companies in Singapore. And if you're interested to buy a copy, you can scan this QR code with this coupon code ICON88, which will entitle you to a 20% discount. Okay, I've come to the end of my presentation.
Thank you, Mr. Boo, for taking us through the COVID-19 Temporary Measures Act by also citing relevant examples, which I'm sure our participants will find very beneficial to put it in context and application. It looks like we have a few questions here that have been posted into the chat. So I'm just going to throw some of the questions out here. We have about 15 minutes for questions and answers. We'll try to answer as many questions possible. So the first one was posted by our participant, and the question is actually a scenario. If there had been 100% delivery to a client and the said client is unable to pay the sum owed towards that delivery since 5 months, and we are talking about the 5 months beginning from December 2019. And right now, the client has also informed that they are unable to pay that sum owed, and they have used COVID as a reason. So will this scenario fall under the relief that you were talking about, Mr. Boo?
Okay, maybe let me just rewind to this slide of the conditions that companies need to fulfill in order to rely on this new law. Timeline is an issue when it comes to, it is actually the main condition that parties will need to rely on. Let's say rely on this new law. We have to look at, first of all, it has to be performed on or after 1st of February 2020. Obviously, for this outstanding amount has been owed from December 2020. So this condition is not qualified. Then there's a second deadline, contracts that were entered into 25th March. Obviously, this contract was entered before that, but because it doesn't fulfill the second requirement, so as far as this COVID-19 Temporary Measures Act that relates to the contract is concerned, I would say that this debtor will not be able to rely on that. But bear in mind that for this COVID-19 Temporary Measures Act, aside from the contractual portion, they also have a separate portion for policy issues. For instance, if let's say you want to sue for insolvency, you want to serve a statutory demand, I think the threshold has been increased from $10,000 to $100,000. Yeah. So, Peter, do you want to add on to this?
And if you look at the contract it was made earlier, the impossibility is not due to the COVID-19. It is in December. So if you go under this defense, I do not think that the court will buy it. Because the court will look at the impossibility of the performance. The benefit has been rendered to the person and he ought to pay.
Okay, thank you for the answers to that question. We have a second question here, which is also a scenario, and this involves a business proposal that has been submitted prior to the pandemic. And would parties who have submitted proposals before the whole situation of COVID turned into a big disruption to our businesses now. If they had submitted these proposals prior to COVID, can these proposals be amended now because of the inability of those companies or parties to fulfill the proposals that were put in place prior to COVID?
This will depend on what type of proposal it has been submitted. A proposal also depends on what stage. Is this proposal amount to an offer, and which has it been accepted? If it's a proposal, you can withdraw it before it's accepted. And this proposal also, even if it's accepted, then it depends on the contents and the terms of the proposal, because the person who accepted a proposal may also not be able to perform. So now you're looking at this situation not only affect one party to a contract, it affects both. So if it affects both, and then it is good that parties will come back to the negotiation table and see how to continue to work on this contract.
Okay. Moving on to the third question that we have from our participants. This will touch on the construction side. So with delays and stoppages of work due to COVID-19, our participant is asking if this would imply that the subcontractors may enjoy an automatic extension of time and additional compensation.
Okay, sorry, what's the question again?
No worries, I'll just repeat it. So one of our participants have asked, and this touches on the issue of construction law. With delays and stoppages of work due to COVID-19, does this imply that subcontractors may enjoy an automatic extension of time and additional compensation? Perhaps we could have both our speakers to give us a little bit of your insight of the situation.
Okay, as far as this COVID-19 Act is concerned, it did not specifically state that there is an automatic relief or extension of time. In fact, if you like to rely on this COVID-19 Act to seek some relief, it is not automatic. You have to actually serve this NFR to the county party, and it's only upon successful service of this NFR, then you can actually rely on it for certain relief. So perhaps the advice, actually the Ministry of Law have provided a set of recommendations on their websites, FAQ, specifically for construction companies. So you might want to refer to that. But essentially, what is provided there is very similar to what I stated here in these slides. That is, first of all, they actually recommend parties to communicate with each other first. Then after that, if let's say you really cannot fulfill whatever has been agreed, then you seek relief under this NFL. So I guess you still have to talk to the other party on how a compromise can be reached. Yeah.
Thank you, Mr. Bu. So I guess a lot of it really also would take us back to the COVID-19 Temporary Measures Act and to rely on the procedures of falling under the relief as well. We have another question here that involves payment of rental, and I will leave it to either Mr. Bu or Mr. Peter Ong to take on this question. If a tenant is unable to pay rental from the month of May onwards, can the tenant choose to terminate the lease, stop payment of rent, and claim for its rental deposit? And all of this, I assume, is due to COVID-19.
You see, this thing is, we accept the fact that the renter has been paid, and the government has already intervened in giving rental rebates of the property tax, and yes, to be given, and everyone is affected in this. So one should not take advantage of another party who has been affected. In fact, the landlord also is affected by this pandemic. So I would say that the landlord cannot evict you, but you can come to an NFR, which the COVID-19 temporary measures has given. There will be an assessor to assess the situation, and then the assessor will look at the facts and circumstances and the contract, the terms of the contract itself, and to see whether how this can be compromised.
Okay, maybe
Thank you, Mr. Ong.
I think Mr. Bu want to speak.
Would you like to add on, Mr. Bu? Yeah.
Actually, it also depends on what being entered into. If let's say it is just a simple tenancy agreement, unfortunately, it's not covered under COVID-19 Act. But if it's a longer term lease where you have an AFL, then you may be able to rely on this. Yeah, but I agree with Mr. Ong on the communication part, right? Yeah, your landlord might be also facing certain difficulties. So you might want to talk to your landlord and sort it out and see whether some sort of compromise. Because in certain tenancy, from my understanding, is that if you break the lease, you have to compensate certain compensations to the landlord. Or in certain situations, sometimes you have to give a certain advance notice to the landlord. Okay, because your security deposit has already been with the landlord, you see. So if you were to terminate this lease at this moment, definitely this lease is going to be, as in this deposit is going to be forfeited. So you might want to talk to your landlord and see whether they can provide some allowance, such as maybe waiving off the notice requirements. Since giving another 1 month of advance notice, it might not, you wouldn't be using that premise anyway. So I think you can try to negotiate and perhaps look back to your tenancy agreement to see whether there's any penalty as well, just in case. Yeah, that's all I have.
Like for tenancy agreement,
Thank you, Mr. Bu.
For tenancy agreement, normally there's a period for waiver for the payment of rental, in the sense that 7 days, not on the day of the due dates. So within 7 days, and if it is passed, that means the party who has failed to pay the rental will be in breach. So this, like Mr. Bu has said, that it's good to talk to the landlord, because the landlord would also prefer to have a tenant to continue to rent it. It is unlikely that the landlord will want to evict the tenant, because after eviction, what comes next? Can he get another suitable tenant or not? So this will still come back to negotiation between the landlord and the tenant. But strictly speaking, on the tenancy agreement, the landlord can do that. And it is not an impossibility to perform. The landlord has already performed and has given the property for the tenant to enjoy. And now on the tenant's part, he or she has to pay. And as for the security deposit, at most tenancy agreement would have stated that the security deposit cannot be used to offset the rental. So this security deposit will be forfeited if the tenant breach the tenancy agreement. So if the tenant were to give a notice to quit, on the contractual terms itself, it's the tenant who breached the contract.
Thank you, Mr. Ong and Mr. Bu, for addressing that question. Because we are lacking, we are out of time, almost out of time. We're just going to take one last question. And this question is also in a scenario where if the nature of business requires participants to be engaged in an enclosed room for a long period of time, and the business is expected to remain closed until Singapore has cleared phase 3, and we are talking about the possibility of the business being able to reopen only from September onwards. Will it then be possible for a business of this nature to rely on the Frustration Contracts Act to end their lease, as they do not have clauses such as force majeure to fall back alternatively? And the nature of the trade is such that it cannot be transformed and moved towards the digital platform. It's a physical attraction. So what options will a person in this scenario have? Maybe we can get Mr. Peter Ong to address it first, and if Mr. Bu would like to add on to it, we can have that.
Can you repeat the question? Is it similar to the tenancy agreement again?
It is similar to the tenancy agreement, but in this sense, the nature of business doesn't permit them to transform their business to the digital platform. It also doesn't allow the business to remain open for an extended period of time, possibly up to phase 3 of the recovery of COVID. So what options will this tenant have? And also this tenant does not have a contract that has a force majeure clause for this company or this business to fall back to. So would it be possible then for this company or this business to rely on the Frustration Contracts Act instead to terminate the lease?
Okay, for the force majeure clause is very strict, because it's force majeure is for possibility that you have to be put into the contract, which you have not put in. You cannot rely on the force majeure clause.
Correct.
So
the contract doesn't.
Yeah, and for frustration is common law. Common law on frustration now is looking at the facts of the case, because your question is a theme as attraction is general, but what of the we will have to look at what the court will look at is the circumstances and facts of the matter, because at this point of time that a lot of uncertainty. That's why the COVID-19 temporary measures comes in, and we can attempt the NFR and look at it and see how the assessor going to view it. Okay, Mr. Bu?
I got nothing to add. Yeah.
So in short, will the tenant be able to rely on the Frustration Contracts Act to terminate the lease, because there's no way for them to conduct the business, and it's impossible for them to generate an income up till September to continue to pay the rent?
It may be possible, but it is also depends on the facts, because there are some cases that the court has held that lack of demand is not a frustration event, and this is really depends on the facts of the case. Because on this matter, I would say that it is, my opinion is that is a possible way to frustrate it, but it's still the court is very slow to do that, because now everyone is using this as a reason. That's why if you are looking at how the government looked at it in enactment of the COVID-19 temporary measures to give people breathing space, like you say, it's until September. You may postpone the obligation, and this COVID-19 even stop the bankruptcy statutory demand. There's normally 21 days, extended to 6 months. So you can if you are looking at this, the court will normally look at what Parliament intend to, and in view of the COVID-19 temporary measures. Because what the court will do is always, if Parliament has enacted this act, if Parliament is silent, what the court can fill in the gap of this. And this is still very, very new. But I would say that it depends, since it is not really impossible, it's just a delay. It's just a postpone until September. Yeah, that is all for me.
Thank you, Mr. Peter Ong. Okay, so looks like we're at the end of our session, and we'll wrap our session with that last question earlier. As we are unable to address all questions asked due to time constraint, feel free to drop us your questions via email at the email addresses found on the slide that we'll be showing you right now. And you may also scan the QR code found on our slide, which leads you to compose an email to us, and that will allow Mr. Peter Ong and Mr. Wu to assist you in your questions. So thank you to Mr. Peter Ong and Mr. Wu Kok Chuan and also to all our participants for taking your time to join us for the session here today. This has been an enlightening session, and today's session is truly to provide our participants with relevant information to aid them during this trying period and hopefully lead them to understand better issues relating to their contractual obligations, especially to those who are affected by time, and we hope to see you in our next session. Have a good evening, everyone. Thank you.
Thank you very much. Thanks, Charmaine.
Thank you.
Thank you.
Bye.
Thank
Bye,
you.
everyone.
Bye.